And we're moving on to part 3 of the prenuptial agreement between Brent Spiner and Gail Chord Schuler and the man on the marriage list. Oh, I lost the spot. Let's go here. This thing played a dirty trick on me. Let's go back up here. Then a psychiatrist chosen by Gerard Butler or Gerard Butler himself, a psychiatrist who practices in England and who played the Phantom in the Phantom of the Opera, will make the decisions about who should be granted custody of the child and how the visitation should be arranged. If Gerard Butler is one of the spouses in the dispute, then Gerard must choose as part of this prenuptial agreement about 10 psychiatrists or mental health professionals that can be used if there are any disagreements about custody of children after the dissolution of his marriage. They must be named and agreed upon in this document as part of the prenuptial agreement, whose advice and expertise must be used as part of the decision over custody. Gerard has been chosen because he is one of the best psychiatrists in the world, with brilliant insight into the minds and souls of all types of people. These psychiatrists and mental health professionals will not, where did it go? Oh, here it is. Will not decide over child support payment decisions. They will only decide who gets custody if there are disputes over this. If for some reason Gerard or any of the psychiatrists involved becomes mentally or emotionally impaired so that they cannot render a fair and just decision in this matter, evidence for this impairment must be proven in court, and then other equally competent psychiatrists will be chosen to make judgments in this matter. Regarding support for the children after marriage dissolution, the party that has custody of the child will not necessarily demand that the party with non-custody must pay child support. If one of the spouses stayed at home and earned little or no income, that party will not be required to pay child support for the child, even if that party is not granted custody of the child. The decision over child support will be determined by the ability to pay and by whose child this is. If the child is a leftover from a previous marriage, and that is not considered a child of this current marriage, then the party whose genes reside in that child must take care of that child. However, if either party agrees to take on the support of the child, despite the fact that there is no genetic link to that child with his adoptive parent, that is certainly acceptable and should be put in writing and signed and dated with witnesses. If both parties brought this child into the world through a sexual act between the parents, then both parents are responsible to take care of this child. Because Gail Schuler is 53 years old at the time, I'm going to be 54 very shortly, at the time of this writing, it is highly unlikely that she will have a biological child with her future husband. So this dispute may be over any adopted children acquired after the marriage, because both parties desired to adopt this child after the marriage. Any children that existed before the marriage will be automatically given to the party that had them before the marriage, along with all responsibilities for child care, custody, and support of that child, unless the parent is abusive or criminal. However, in the case of children acquired after the marriage, if one of the parents stayed at home in a job with little or no income in order to care for the children, then the parent who was able to maintain his or her income will have the primary responsibility for child support because he or she has the greater ability to pay. The parent who stayed at home during the marriage so that he or she had little or no income of his or her own in order to care for the children will not be required to pay any child support until and if that parent obtains a job or income that pays him or her as much as he or she could have earned if he or she did not stay at home to care for the children, or at least enough income to pay for his or her basic needs plus child support. Also, if the former stay-at-home parent cannot acquire a job or income that pays him enough for food, housing, and basic needs, plus child support if child support is necessary, that parent will not be required to pay child support after the marriage dissolution until and if he or she acquires a job or income that pays him more than his basic needs, so that child support payments will not destitute him or her. Any child acquired after the marriage through adoption that was only desired by one party, in which that party imposed this child onto the marriage against the wishes of the other, is not considered a child of the marriage, but will be considered a child of the spouse who desired that child. In cases such as this, that child will go to the spouse who desired him or her, along with all the responsibilities for its support and care. If the unwilling parent during the marriage later becomes a willing parent because he or she has fallen in love with the child, then this child will be considered the child of both parents that love this child, and both parents are equally accountable for its care and support. Evidence must be shown in court that this child was not desired by one parent only and was not forced upon any parent against his or her will or knowledge. Any spouse who is coerced into adopting an unwanted child should protest to the adoption agency. This should stop the adoption immediately. If it can be proven that the protests were blocked or hindered, then the adoptive parent can claim he or she was tricked into adopting a child he or she did not desire, and that was not the result of his or her sex with the child's biological parent. Just because the child has the genes of the parent does not mean that he or she had this child through willing and knowing sex with the biological parent. We have many sexual crimes committed today where sperm or eggs or genetic material are stolen and used to impregnate women who have never had sex with the man who has the sperm that impregnated the female or the genetic material that impregnated the female. Therefore, evidence must be proved that the pregnancy was caused by this man or woman having willing and knowing sex with the other genetic parent of the baby. Gail's enemies often use unwanted children as a means to cement a relationship together that is not based on love or commitment of the partners to each other. If such a stratagem succeeds, it is not fair to the spouse or the child who was coerced into being a parent when they did not desire the child and had no sex with the party to create the child. Ideally, no one should adopt a child unless both parents desire it, but this is an imperfect world, and mistakes happen, and crimes happen. And so that is why this section has been written into the prenuptial agreement. No one should be forced to adopt a child just because that child has his or her genes and he or she did not willingly and knowingly commit the sexual act required to bring that baby into the world. We will not encourage the clever sexual crimes involving stolen sperm or reproductive materials so rampant in today's society. For the purposes of this document, basic needs are defined as the amount of money needed to maintain health and a roof over one's head. It does not mean the amount of money to maintain an extravagant lifestyle. No spouse will be required to make payments on billion-dollar homes or Mercedes-Benzes and expensive cars or boats or yachts unless they are stuck with the payments on them and they need to avoid creditors. In that case, they must try to sell or replace the expensive property within a reasonable amount of time and live less extravagantly. At the time of marriage, dissolution, I didn't mean resolution, I meant dissolution. They will be given a reasonable amount of time to sell or replace the expensive property in order to pare down their expenses if they claim they need income from the other ex-spouse to make payments. If they do not sell or replace that property within that reasonable amount of time, or for some good reason can't sell or replace that property without a loss, then their need to make payments will be respected. However, if they fail to try to sell or replace the property despite their best efforts, and evidence must be provided that they have tried to sell or replace the extravagant property in order to pare down their expenses, then they alone will be responsible for payments on that extravagant property. They cannot allow any ex-spouse to be responsible for payments on their own extravagant lifestyle. Payments for properties that are luxury items will not be required of any ex-spouse. If the luxury item is a temporary necessity, like an expensive home, or an expensive car that is needed to have a roof over one's head or is needed for transportation, then allowances for alimony payments for this item will be considered until that expensive item can be replaced with an item of lesser value. Exception: if the payments are almost paid up and it is cheaper to keep the luxury car or house, then payments will be required until the property is paid off, and then the required alimony payments for that luxury but necessary item must stop. An automobile is a necessity, so allowances will be made for a car, but it doesn't have to be a luxury car, and 2 cars may not be necessary. No spouse will be required to finance an extravagant lifestyle for the other at the time of marriage dissolution. The goal of this prenuptial agreement is to ensure that the health needs of all parties are met at the time of marriage dissolution, and that all can maintain a roof over their head and have basic needs met, and that no party takes advantage of the other to maintain an extravagant lifestyle at the expense of the other party. People should go into a marriage because they want to love and support the other, not because they hope to obtain an inheritance from the spouse after they die or divorce. If for some tragic reason the marriage must end, it should end in a manner that makes it easy for all parties to go forward with their life, and to not be crippled with debt, creditors, and financial pressures caused by the cold and ruthless acts of any party. Both parties agree in this prenuptial agreement that if a marriage breakup occurs, both will do all in their power to honor the spirit of this prenuptial agreement, to allow all parties to go forward with their life, and to not cripple any party with unnecessary debt, creditors, or financial pressures or outrageous requests for alimony or child support that would debilitate any party. If an ex-spouse has a medical condition that requires that he or she needs to spend more money than most to maintain health, and therefore cannot pay child support because of this, that spouse will not be required to pay child support because he or she lacks the ability to pay. Gerard Butler, an MD who practices in England, or other MDs or physicians whom he chooses to assist him, and who must be named and agreed upon in this prenuptial agreement, in case he is the ex-spouse, will determine what type of income the ex-spouse needs to maintain his or her health at the time of marriage dissolution. And if any soon-to-be spouse lacks the income needed to maintain health, or only has enough to pay for his or her own health expenses, and has no money left over after this, that debilitated spouse will not be required to pay child support or alimony because he or she lacks the ability to pay. The amount of income determined as necessary by these health practitioners must match the current cost of such needed health care at the time that the spouse needs these services. If it does not, then that health practitioner's assessments will be disregarded as invalid, and another opinion must be obtained to obtain a fair assessment of monies needed by the ill spouse for health maintenance. All health practitioners that Gerard Butler chooses to work with him in drafting legal documents about health maintenance costs must acknowledge acupuncture, chiropractic, and natural medicine as viable forms of health practice, and must allow, if necessary, the use of these alternative medical treatments and the expenses involved as part of the required health maintenance costs of any ex-spouse who needs these services to maintain his or her health. We're going to close up and go to another one. Start another video.